Okay, is my screen is up? Everything is good. All right. So yeah, thank you for the invitation to be here. This research project comes out of my capstone project for Masters in Urban Planning at UCLA. This was a project that was done for clients, joint clients. That was Sage and Inner City Law Center, who fight for tenants' rights here in Los Angeles. And this was on behalf of the LA Tenant Right to Counsel Coalition, fighting to achieve a codified right to counsel representation for tenants in court. So as I will show here in the study, that the current mechanism of the court system serves to benefit landlords, and tenants not having legal representation will be most likely losing their cases in being able to challenge their evictions. And so I put here, you can follow the right to counsel Los Angeles at RTC Los Angeles, and also the website. And with this research also was supported by the UCLA Luskin Institute on Inequality and Democracy, where I'm continuing to do some part-time research there on LLC landlords here in Los Angeles. So the title of the research project here that I've done is Piercing the Corporate Veil of the LLC Landlordism. Piercing the corporate veil is a legal terminology of describing when courts actually hold the owners of either corporations or even LLCs fully accountable for their actions. So I will talk about how the LLC has provided that protection for bad behavior. Again, and this is an in-depth case study to really do a comprehensive examination of what is predatory landlord behavior. Usually tenant struggles are looked upon as simply anecdotal evidence, right? That this landlord did this behavior, this other landlord did this, but also as we're seeing with the rise of LLC landlords, it could be that you have one landlord in this neighborhood, another landlord in this neighborhood, and actually are under the same ownership. So here with this research is an in-depth case study looking at an eviction machine of Black and brown bodies in Los Angeles working class neighborhoods from 1996 to 2019. So I want to begin first just kind of describing the characteristics of a limited liability company, LLC. Typically, it's misunderstood that an LLC is a corporation, that's this kind of large, sophisticated organization, but in reality, they are not subject to corporate taxation, and that was part of the reason through its formation to be able to get that financial tax benefit. The other piece is that they have minimal public disclosure requirements for investors. So to create an LLC, all that is required is a registered agent to be listed to receive any legal or government notifications. But the actual investors or people behind the company are not required to be identified. And even in the statement of information document that's required to submit to the state, they are only required to identify one person. So it could actually be the owner, it could be an employee of the company, it could be another company name, which then will require to go further digging to see who really is behind these companies. And then last piece, most importantly, is this granting of limited liability protection. And this is the feature of a corporation, where corporations are paid, part of the reason they pay this corporate tax, is to get this protection where not the owners of the company cannot be personally held liable. So here with the LLC, this is where they also are able to benefit by not being held personally liable, even though the individuals behind the company are the ones that make the decisions to use these bad behaviors, cannot be personally held liable. So LLC landlords, are not mandated to provide their personal identity to tenants. That's why you will see notices just identifying the LLC, an address, potentially could just be a PO box, and then just a phone number that could be to an undisclosed location. And so the way the LLC the legal structure has allowed this LLC to receive the full benefit of the company is your landlord, not the individuals, but the company. And this, as what I would show again in this study, produced kind of allowed for predatory landlords to exploit this entity. So here was just kind of a quick timeline of showing how the LLC came to rise. So the state of Wyoming in 1977 was the very first state that actually introduced LLC legislation, but it was really in 1988 when the IRS ruled in favor of this kind of pass-through tax status, which is what I had mentioned, not subject to corporate taxation. So the individuals, their profits, they're just taxed at the individual level. And when that decision was made, we saw kind of all the kind of states start including their new legislation. So by 1992, 18 total states, 1993, 36 states. Here in California, it was in 1994. And then by 1996, all 50 states had already implemented LLC legislation to the state books. And then the last piece here is in 1997, more deregulation here from the IRS, allowing no longer being as stringent in trying to determine, is this actually more of a corporation, a general partnership, or an LLC? Now it was, as long as you're not a publicly traded company, you are can be an LLC. And again, an LLC could be from one individual to a larger group. You know, the LLC has been utilized by predatory landlords, and when it's in their hands, you know, some studies have shown them to be identified as code enforcement dodgers, where you're not able to identify who should be really held accountable for slum housing conditions, or also just known as an organization of neglect, where when an LLC actually purchases your property, the housing conditions, quality of life actually declines. But the kind of studies that have been done in the past have focused more on housing conditions. With my study, I really want to focus on the predatory landlord behavior with regards to evictions and displacement. And for my study, what I have described here is that now the LLC has become the apparatus to serve the eviction machine of Black and brown bodies. Just so quick background, so where this kind of study kind of is rooted at and identifying the specific landlord is when I had been a former organizer for a nonprofit for a number of years here in Los Angeles. And this building here that I had organized in 2015, 2016, the new owner, again, the landlord identified as 1819 South Gramercy LLC, had purchased the property in February of 2015, and tenants had just, again, received a notice of this LLC, a PO box where rent will be mailed, and a phone number, and that's it. And it's just having individuals or agents of the landlord coming to the property, telling tenants there's going to be changes to this property, telling tenants that had Section 8 vouchers that they needed to leave because the landlord did not want to accept them, that the landlord would help them move out, and then immediately started doing these exterior renovations. So like as kind of here in the picture showing in March, just within a month, right away, doing these exterior renovations without any advance notification to tenants. So causing disruptions to utilities, noise, access, trip hazards, parking. And when we attempted to try to engage with the landlord and ask that we meet with them to really understand what is going on, they totally refused. Then tenants really kind of found the name of the management. They finally identified themselves as KMM Management Inc., which also was under the ownership of the actual owner, whose name is Abraham Stein. And so it was a struggle of then being able to try to actually engage with the landlord and voicing some of these tenant concerns. And so when a tenant actually called the office to say, can we set up an appointment, come to your office to talk about what's going on, they said, we don't have an office. Of course, after doing some research, we found that they actually had an office nearby. So we had set up a delegation to visit the office. Of course, once we got there, they refused to engage with us. And, it was very clear that this landlord had no interest to develop any relationship with tenants. They had a clear mission to just treat this homes, property as just real estate, and that the bodies of tenants here were just in a way of being able to raise rents. And so, after I had, we did this organizing, the landlord actually retaliated against the tenant leader, filing eviction notices, 3 within a span of 5 months. And so this gave more evidence of this predatory behavior. We had seen that properties nearby were going through the same transformation. So we saw here that, again, it was not just in one building, but happening in other buildings, and same evidence and concerns were being expressed. So we knew that clearly this was a large landlord and was applying the same behavior to other properties. When I did here in my research, kind of looking back, the history of how far back did this landlord actually own property, and it goes back to 1996 when all properties also had been acquired through LLCs. Here in this graphic, you see all the different LLCs in this large network were more, again, primarily they were named by the address of the property. So in total, it was 171 properties, over 3,200 rental units. It was a kind of complete housing portfolio for this landlord. They don't own, he doesn't own all these properties currently because his behavior shifted based on the market conditions, which I will share a little later. But with also looking at all these LLCs, one thing that I also found is that, again, it was very targeted acquisitions, and these were coming into working class neighborhoods of color here in Los Angeles. For those.
Sorry, can I just ask you to slow down or take a pause between sentences for Betty? Thank you.
Yes. So here, this provides kind of a visual of the neighborhoods, and you can see here the concentration of all the properties in these top neighborhoods of being Koreatown, East Hollywood, Westlake, Inglewood, Hollywood, Mid-City. And you see how the number of units and properties align there. And then here at the bottom, you can see that once this kind of campaign started to acquire properties, it was very rapid. So looking at some of the first acquisitions in the neighborhood of Westlake, April 96, Koreatown, July 96, East Hollywood, December 1996, Mid-City. So it was just this kind of rapid acquisitions of properties. This kind of just provides a little information that I probably will kind of skip over, but it just showing demographics and vulnerabilities from these neighborhoods where you had high rates of poverty, unemployment, high numbers of immigrant populations, low income, lower education levels compared to at the county level. And so, the other question was, well, was it just coincidence that this was the neighborhoods that were selected because, this is what he could afford? We kind of hear that argument a lot of times. So we're talking about gentrification of like going into neighborhoods because that's what could be afforded. But in reality, when I did a deeper dive into this history, is that he actually had already owned property previously in more affluent, more richer areas in Los Angeles. And part of that mostly went West Hollywood. And you can see also the numbers contrast here is that you had higher number of population of white population with higher income. So previously, he already had the purchasing power to get higher rents, another demographic, but then made this sudden shift to these working class neighborhoods in 1996, which exemplifies, again, the predatory behavior. And the next piece here that I also was asked, well, how were renters, maybe treated here in West Hollywood? And the evidence was showing that he actually had no interest to serve renters even in these areas because he was initiated a campaign of condo conversions. And so this is just list of the conversions. You can see here rapid acquisitions of these properties and the conversions that were occurring. So even in these more kind of affluent neighborhood, it was exacerbating the affordable housing prices there as well by doing these condo conversions, making it more unaffordable for tenants, low-income tenants, to even be able to reside in these neighborhoods. So when we shift and look again, now going back into the current working class neighborhoods, here previously he had initiated a campaign of condo conversions. The next shift in his predatory behavior was the creation of this eviction machine. And so here is the kind of total cumulative unsealed eviction filings from 1996, 2019. And what the numbers show is, again, that every year, there's no eviction-free year. Every year there was evictions and the numbers continue to increase, making it very clear that this was part of the business model. And so here, with the total amounts of adding over 1,500, as I had mentioned previously, in comparison to the total housing portfolio, it adds to about, represents for about 46% already of his entire portfolio of just already the total number of eviction filings. Here, you can also see kind of at the end, seems to be kind of slowing down. And the question is, well, did his behavior change? I will show later in the study that it has not, but because of the changes in the law, a lot of the current eviction filings are sealed now. And that is something that now needs to be combined. And that's what I did with this study, to really show the full picture of the eviction machine. And what I mean by unsealed is that they're available as public record from the court. Here, it's very clear that, again, eviction filings, from looking at just say the top 6 neighborhoods, are found in all the neighborhoods. And here you can see in the table, the total eviction filings plus the total number of units that were owned in these neighborhoods and the kind of percentage that was represented of the evictions that were filed in these neighborhoods. So everywhere the property was acquired, the mission was very clear of displacement and the need to push tenants out to trigger vacancy decontrol and allow for new rents to increase. One thing that also with the study, or I wanted to do, is really look at who are the actual tenants who are being evicted. So previous studies have kind of inferred based on the location of where evictions are happening, who based on their race, who is likely getting evicted. But I was able to kind of take from another study that was done where a statistical tool was used to take the tenant's last name and their census tract to do an estimation of what their racial demographic is. And when I applied that tool to all the eviction filings for the tenants, it was very clear again that who he was targeting for these evictions were Latinx tenants, represented 57%, Black tenants accounted for 24% of all eviction filings. When I looked at closer into the actual neighborhood, so looking at, say, the top 6 neighborhoods, the racial targeting becomes more clear and seeing disproportionate amounts. So here, if you look at for the table on the top, shows the percentages of the racial demographics for the populations. And at the bottom identifies based on the percentage of the evictions that were done for that neighborhood. And those that are identified red at the bottom show that the eviction rate was higher than the racial demographics of the neighborhood. So from this visual, you see that Latinx tenants counted for the majority in 4 of those 6, Black residents accounted for 6. So just so more extreme examples we see here in East Hollywood, where they represent 57% of the neighborhood, yet they accounted for 77% of all the eviction filings. In Hollywood, they represent 47% of the neighborhood, but accounted for 67% of all the eviction filings. And then for Black residents in Inglewood, they represent 43%, but accounted for 69% of the eviction filings. In Mid-City, 23% of the population, but again, 69% of all eviction filings. So with this research, it was very clear that this is an eviction machine directed at Black and brown bodies. And not only do we know what neighborhoods, but clearly who were the tenants that were evicted and targeted for eviction. And once we get into the court system, as mentioned, is that the court system is not friends to tenants. And with looking at all the eviction filings, I found that 83% of all the cases were lost, compared to only 14% that were dismissed. So it's very clear that once the eviction proceedings begin, his intention is to fulfill that and lead to eviction. And so looking at it closer here at this 83%, I wanted to see, well, more precisely how the tenant lost. And what it came out to be is that over half, 51%, actually lost by default, which means that the tenant did not even have the opportunity to respond to the court notice and lost, didn't have the opportunity to challenge their case in court. The other important piece here is that the 9%, which is kind of this kind of failure to appear to their court hearing, also essentially could be viewed as a default because they didn't even make it to their court hearing. So really it comes out to be being 60% of the cases were lost by default. And this is part of, the mechanism. Also, this predatory landlord exploits the legal system to evict tenants when we know it's a convoluted legal system without legal representation. They will surely lose. And even here, the evidence is clear, as seen in also across many cities, that only 10% of the tenants in these cases were evicted, had legal representation. The next thing to understand with predatory landlord behavior is that eviction is a measure of first resort. Many times we hear a lot of landlord organizations say that eviction is a last resort measure, and they usually will throw in kind of the mom and pop landlords at the forefront, right? Saying like they don't want to evict, but again, predatory landlords who have the economic capital and to manage turnover costs, it is their priority to get tenants out. And so when I looked at the total housing portfolio, over 500 or 34% of the cases had been filed within 1 year of acquiring the property. Again, making it clear that the mission was to acquire and get tenants out. And, more significant is looking at all the total of the 171 properties I had showed earlier, the LLCs, 66% of those had evictions, formal evictions that were filed within 1 year. Again, adding more to challenge this idea of eviction as a last resort, there was no evidence to show that really, if it's a last resort measure, then we would see high number or tenants being behind on rent for several number of months, right? But in reality, it was showing here that, again, the majority, over half, was due to up to 1 month of rent behind on rent. So when the opportunity comes, this landlord will serve eviction. And I say here up to 1 month because I also, when I was looking at the data, realized it was not just a few cases that were less than a month, but when I did more further separating out that column, almost 10% of the cases were due to less than a month for rent, behind on rent. And this is something that I will show a little bit later, is that there's also this predatory behavior of being able to manufacture either illegal rent increases or other just kind of baseless fees are being added to then be able to create the circumstance for non-payment of rent, which I will kind of describe a little later. The other thing, again, adding to the evidence of predatory behavior, that these evictions are not just, when I need to go to court, this tenant, I gotta evict them, but really that these are bundled, so they are packaged together, and over 800 or 50% of these cases were filed in a bundle of 2 or more. So what I did was look at the filing date and see that there was matches of different cases that had the same filing date. So it's very clear when they go to court, they file it in bundles. So here are just some examples of what you see here: the date that was filed, the number in total that were filed, and then the number of properties with the number of units from each of those properties. So while it's usually argued that, landlords should be concerned about turnover costs, the evidence was clear here that this landlord is not concerned or worried about that. Again, eviction is the first resort measure. And these tables are in kind of chronological order in the year 2000, 2002, 2003, again, 2004. It's ongoing behavior. And so I stopped here kind of looking at just for this example here of 2006, because it was a very specific campaign that was initiated in this very first decade. I noticed that there were, again, as I mentioned previously, this rapid acquisitions of properties, but I also noticed that properties were being sold pretty quickly. And so here in this first decade, you see this rapid slope. But in by 2006, a total of 123 properties had been acquired. But if you look at the number here, again, this tape graph accounts for just owned per year. So if they sold, the number changed. Actually only adds up to 90. So that means it was very clear there was this property flipping campaign that was initiated. And looking at the properties, these 123, here kind of are the breakdown of kind of nearly 20% flipped within 2 years, another 25 between 3 to 5 years, another 25 between 5 to 10 years, and then another 10 after the 10-year mark. And so only from the properties that were acquired during this decade, only 22% are still owned today, showing that, again, that in order for this also property flipping, in order to get the highest value, the landlord was evicting tenants at a massive scale. And here, this period, the peak period of this flipping was really from 2002 to 2006. And the table kind of shows the averages that really what was happening during this period is about 19 properties were being acquired and like 7 were being sold at the same time annually during this period, with about 170 eviction filings being done also yearly. The following decade, and this is again post-Great Recession, which you had new rise of gentrification, it shifted the landlord's behavior of now holding on to the properties and capitalizing on the arrival of these gentrifying forces, right? Whether it be from the unprecedented rise in rents, property values, luxury developments, and then the influx of white renters. This is here now the current portfolio of what is owned today. So a total of 65 properties, but over 1,200 units. And really what kind of set in motion was this new business strategy was when this new KMM Management Inc. was incorporated in 2009. And again, showing that from the 43 properties that have been acquired since 2009, only 5 have been sold. So you see this shift in behavior where first decade was spent flipping properties, but then with the arrival of gentrification, now holding on to the properties and benefiting from those forces. And here what I also had seen at the Gramercy Place Apartments was this exterior renovations that were being done to transform the outside of the property to kind of sell this luxury living. But in reality, again, the treatment and conditions for tenants inside were still being the same. And these are just some images showing clearly this kind of transformations of before and after of some of these properties that were being transformed, making it clear that, again, the mission was to be able to capitalize on these gentrifying forces, even for properties that had been owned and were kept previously. They went now through this process. So only the transformations were occurring during the period when the most return could be made.
Joel, sorry, can I interrupt you for 1 second?
Yeah.
So we just want to see whether there are still people who want to hear the presentation in Spanish. So I'm gonna, for a second, allow people to unmute themselves. Joel, could you just make an announcement in Spanish asking if there's anyone who's listening in Spanish?
Sí, so la pregunta es si hay personas que todavía necesitan español, si le pueden poner, decir esa información aquí en el chat.
Or just speak up, because everyone should be able to unmute themselves now.
Ok, sí, so pueden decir algo ahorita porque Betty, que está ayudando, está preguntando si todavía es necesario. ¿Hay alguien aquí que necesita español?
Okay, thank you so much.
Okay. Do I continue? Okay,
Yeah, thank you.
let's see. Okay, and so what I had mentioned earlier is that towards that period at the end when I showed the cumulative eviction filings, really what was shown is that there was kind of a slowdown of the total eviction filings. And so the question again was, well, did the behavior change or what happened? But really here in Los Angeles, specifically what had happened is in the year 2013, there was a new kind of funding provided for eviction defense provided for tenants. And then in 2017, the law also changed where eviction filings would now be permanently sealed from public record unless for sure the tenant lost by default, then they would be showing. So when I was just looking at the unsealed eviction records here, kind of this decade of 2009, 2019, it was showing this over 300. But in order to really capture the full story, what I did was request some data from some of the legal agencies that are part of the Right to Counsel Coalition to share some of the data to really show how many eviction cases they actually represented from this specific landlord. And really and this was 3 organizations that had shared some data. So only a fraction of the existing legal agencies, that the number immediately jumped, adding over 140 eviction filings that were cases represented by these legal agencies. So really it shows the slope, actually what the reality and the treatment is of how the eviction machine operates. So only by really combining the unsealed with sealed eviction records will you be able to get a kind of complete picture of what this eviction machine looks like. And so now really combining the numbers, it's really showing that even where it was at before, breaking the 50% threshold of even from the total portfolio of over 3,200 units, now over close to 1,700 eviction filings, representing over half of what had already been owned during this entire period. The next piece here is that one thing with my study is I wanted to really go also beyond just the eviction numbers to really show more the behavior that was being exhibited on what was happening at Gramercy Place Apartments. And also were these evictions, from these properties that were acquired, were they non-rent control, right? Where there was less tenant protections? Well, in reality, actually, is that I had seen here looking at the properties that over almost 2/3, 64% of the entire portfolio actually were subject to rent control, which for those not in Los Angeles, LARSO is the Los Angeles Rent Stabilization Ordinance. And so this is also, as many tenant organizers know very well, that there is this targeting of rent control housing because you have the long-term tenants who are targeted to get them out to increase rents. But as I mentioned, in 2009, when the kind of campaign had shifted, that really looking at the current properties, it actually increases to 75% are subject to rent control. So if we think back to, say, in 1996, when he arrived, he had this period of, being a landlord for the first time, because before that, right, it was condo conversions. You would think that even with existing rent control protections that it should deter landlords from operating these properties. We always hear, at least I hear all the time, you never want to own rent control properties, but for predatory landlords, they actually target their acquisitions and actually has become their priority. So for Abraham Stein, even his last 36 acquisitions were stretching back all the way to 2011, have all been rent control properties. And even in these rent control properties, what I, again, was showing beyond the numbers is really also the systematic, deliberate violations to the rent control laws. One of the big features here of this predatory behavior is the serving of unlawful 90-day termination notices of Section 8 to Section 8 tenancies. So here's an example of a 90-day notice, which had already been ruled since 2010, that if there is rent control, those protections apply to tenants, and that these 90-day notices would be unlawful. Yet we see here in 2014, it was still being served. Then in the same property, again, it was now in 2019, it was served again to the same property. And this information that I'll be sharing about these violations, comes from public records requests from the city's housing department of tenant complaints. So this behavior here is constantly being repeated because the enforcement mechanisms here in the cities are not severe in any way. They tell the landlords, this is illegal, don't do it. Rescind the notice, moving on. But again, it doesn't stop from this behavior to be constantly being repeated. So I used a sample size from 2014 really to kind of 2019 to look at tenant complaint records. And here in this table, what it's showing is that for all these different properties that are highlighted in their own color is that the behavior is repeatedly done until tenants also, not only even if you do file complaints and stay there, you're still dealing with ongoing harassment. And so here for the 1427 Point View LLC, it was served in 2014, served in 2016, and in 2019. Same thing for these other properties, Lockwood Investors. The years are constantly being repeatedly over. And so you see here that not only is it kind of these mass distributions of these notices to the Section 8 tenants in these properties, but just because it was dealt with in 1 year, that it will be constantly being attempted to be done again in several years later. So like, for example, Gramercy Place Apartments, where I had organized, it was in 2015, you see here that we had filed complaints, but then in 2017, the efforts were made again to serve the same notices. And part of the reason why these notices or this behavior, predatory behavior, is being repeated is because, again, as I mentioned, there is no real punishment for this. And the Abraham Stein also exploits the bureaucracy with the city housing department to be able to get tenants out. And this results through like the closure of tenant complaints. So we have here what's highlighted in red, that even tenants who filed tenant complaints, it's not guaranteed that their housing will be preserved or they're able to keep their home, because in order for a complaint to be investigated and enforced, there's certain documentation that needs to be submitted. And if not all of the documentation is submitted, the investigation will not occur and the case will be closed. Or the other thing is also kind of this, where tenants will move before the completion of the investigation. Many times the engagement with the investigator, with the tenant does not go well, and the tenant does not have hope or belief that actually this enforcement will take place. And in this case here, for the tenant moving out, what these notices are being used for is to be able to create this fear, right? So even though, say, these 90-day notices are illegal, and the landlord would use that notice to create the fear to then be able to force the tenant to accept buyout agreements, cash for keys. So here in this notice here is one of the examples of the tenants who moved out. And this is actually here the landlord response to the housing department. And one thing here that's important to look at is just totally ridiculous is that, the notice does state here that they are rescinding the termination notice. But then if you read this next piece, what they're saying, even though the termination was resigned, where they meant rescinded, the tenant approached the landlord with the intent to vacate. In order to avoid further problems, an agreement was signed, which this is kind of a copy of it. But just again, showing this terrible predatory behavior of trying to flip and say that the tenant was the one who wanted to move out, when in reality, if this notice was never served, that would never have occurred. So even the language that they use is trying to create this narrative that, again, it's the tenant wants to move out, when in reality, their eviction machine is in full operation. So not only with Section 8 termination notices, the other big systematic behavior was these unlawful rent increases based on unauthorized occupants. And so this is done in two ways. Either they'll serve it in a 3-day notice to perform, or in a notice immediately of change of terms and tenancy. So if we look at here for this property 909 South Bonnie Bray LLC, we see here that they talk about how an inspection was conducted and that it came to their attention that they had 8 people in their unit, and that even their rental agreement says that they should only have 2. And that immediately that the rent would be increased of up to 60%, or unlawful retainer will be filed against you. So pay the increase of 60%, or unlawful retainer will be put against you. Here again, in this version, they're saying that it came to our attention. So this is like all the evidence that they are saying here. Like, it just came to our attention. But in these notices, again, also the city enforced it and said, well, there's no evidence to show that it just coming to your attention. There's no evidence to show who are these unauthorized occupants. Have you attempted to even discuss or to talk about who are these people? No, it was just straight to these notices of eviction threats, or in this case, to illegal rent increases. So here we have a notice where 30% rent increase was sent. And so with these baseless notices, this is part of the effort to manufacture non-payment of rent circumstances, because when you go to court, that used for non-payment of rent, that is the method to swiftly get tenants out the quickest as possible. And this makes it very clear where even when a court case goes to, or a case goes to the court and it's for non-payment, it requires to go further investigation to figure out whether that even rent that they're asking for is even legal. Because not only do we have circumstances where you have illegal rent increases, but then also in situations where even the manager will not accept it. And I'll show an example of that a little bit after as well. So similar to the 90-day notices, these are notices of illegal rent increases that are being served in mass numbers. So this, again, this example of the 909 South Bonnie Bray, just all the notices that were all served on the same date of May 30th, 2017. And again, what results is still here, just tenants will end up moving out. Again, filing the complaint is not guaranteed that their homes will be protected. Another thing that again shows the need to change the enforcement mechanisms in the city, and I'm sure elsewhere, is that this is just a notice that the management sent to the housing department saying, yes, we're gonna rescind and cancel all these illegal rent increases for all these properties. And you would think that if, as an enforcement agency, when you receive something like this mass number of illegal rent increases, clearly that this must be behavior that's also done for all the other tenants, and that should be, investigated and enforced. But unfortunately, the way the current enforcement system works, it's all complaint based. So the tenant would have to file a complaint in order even for their case to be investigated or taken into consideration that there's also illegal behavior. And so that is a big flaw, and part of also this research to really kind of demonstrate that. Here, I'll just kind of go through this quick, but another example here that this behavior is done constantly over and over. This was just a response from an attorney for one of the tenants notifying the landlord, because this was in 2017 when they received this notice of alleged unauthorized occupants in 2017. The letter here pretty much just kind of talks about that, we received, this tenant received the same exact notice. So here's, they've included a copy in 2013. So you were alleging in 2013 that there was unauthorized occupants, but then again, you're serving the same notice again in 2017. By now, you would think they know who lives there. Again, this predatory behavior is systematically done and on a consistent basis moving forward. And in order to really continue this behavior, one of the things that I saw here, and was also the example at Gramercy Place Apartments, is that these tenant questionnaires are sent to tenants. Like once the property is acquired, these questionnaires are sent out, and they're made to seem kind of this harmless. We're here, we're interested in serving you, right? We would like to update our files, is what it's saying, dear tenant. Fill out this information. But really, what this is used, because we know that a lot of times there's verbal agreements made with landlords, right? And usually it's not put into written form. And especially when the property is sold, those new changes are not included in the original agreement. So this notice makes it seem like, we're here to hear what are these kind of changes if it doesn't match with what's written. But in reality, is that once these tenant questionnaires are filled out, then they dissect every piece of it and see where there are discrepancies from the original contract, and then start serving these unlawful rent increases. And so here's kind of an example of that happening, where this tenant in the property 2340 Crenshaw LLC was served immediately, September of 2016. Tenant filled out the information, and already within 2 months, they received this notice of change in terms of of a $200 rent increase, because what you wrote in here doesn't match what was stated. And again, no effort being made to really talk with the tenant to find out what were the changes. And again, that this is not an innocuous notice, but really was the intention is to find these discrepancies and then use it to serve as part of this eviction model. The other thing, again, how they manufacture more non-payment of rent circumstances, so applying illegal rent increases to security deposits. So here's an example of one property, Willowbrook LLC, where it states here the company policy dictates that the tenant security deposit equaling 1 month's rent must be equal to the rent amount. And so here they're saying, well, you have a balance of nearly $270, and that we're giving you to September, right? So it's not even a 30-day notice if this was even legal, but there was no 30-day notice, giving you September to pay off the remaining 270. And then most important here, we see if this amount is not paid, we will be forced to deduct that amount from that month's rent payment and proceed with legal action. So this kind of goes back to what I had shared earlier of showing that just the households that had received an eviction that were less than a month's rent, and we kind of here have an example where these illegal rent increases, manufacturing of supposed unpaid balance, then are able to use to go to court and say that it was a non-payment issue. So even though the tenant just said, no, this is incorrect, I'm going to pay my rent, they're going to just use that rent to say, it's deducting this amount, and now you are still below rent. And so here, this table just kind of shows 3 of the examples of the rent increases, 22, 44, 51% rent increases. And at least in this case, these were the tenants that were actually were reimbursed after enforcement was done. But we know that, again, for many of these cases, the tenants do not have the money just to pay these illegal increases and let the enforcement take place. So that will result in eviction again. And this is part of, again, capitalizing on kind of the bureaucracy of how the enforcement mechanism works with the city housing department. Building-wide eviction threats was found in these properties, just showing kind of the hostility towards renters. So here at this 535 North Heliotrope LLC, this is a notice telling all tenants that literally that they are in violation of, I guess, storing their belongings in the parking lot hallways, and that this is a 3-day notice to comply. And if no action was taken, that in this case, legal action will be taken. And this is something that is unlawful behavior. When you have a tenant is in violation, you serve a 3-day notice to the tenant directly and identify specifically what happened. In this case, they're using a 3-day notice to notify everybody that you're all in violation, and that the next step could be if we're going to file eviction procedures. Another one here, just more harassment, removing personal belongings from your own balcony. If not, action will be taken to remove them, discard them. Another example here of, again, even hostility to families and social gatherings at these properties, of not having given the ability to have any parties or gatherings in the common areas. Again, even though these are multifamily designated homes, they are controlling the space and the behaviors of all tenants. Same thing here, just saying all these violations that tenants are saying as a whole are doing, and again, that we would take legal action if this is not resolved. But all at the same time, while all this hostility and harassment is happening, they also, are reducing their services. So here's one example at 1648 St. Andrews LLC, where they actually demolished the garage spaces and said, you just have to move your belongings, move out, we gotta do this work. But then there was no information of providing any compensation for the loss of that service, and no date of when the tenant will be able to return. Here's another example here where they're notifying of maintenance, saying, more specifically, the most important piece is that they're saying that the tenant is responsible for any plugging or clogging that happens in sinks, toilets, garbage disposal, bathtubs. So they literally are saying, we're not going to address any of the plumbing issues at the property, which is illegal. Landlords are responsible for all the systems in the property. But they point out down here that they would be gladly to perform this maintenance for a fee of $75 per visit. So they are trying to pass on their responsibilities to the tenants, or have obviously been doing it. So while you have this arrival harassment leading to evictions, you also have the reduction in housing service and responsibilities. So it is no surprise that actually that there are a number of lawsuits that have been filed. And just this is an example of just within the last decade of some of the lawsuits that have been filed in these properties. And here as a breakdown that within the first three, just see the percentages of taking the averages of like all these cases and showing that within the first three, negligence, premises liability, breach of warranty habitability, this all deals with the reduction in housing services and the lack of serving tenant interests and dealing with habitability. Then the next kind of triad here is dealing with the harassment that is constantly happening through private nuisance, breach of covenant of quiet enjoyment, and intentional infliction of emotional distress. So even with looking at the administrative record, public court record, the evidence is here to show the predatory behavior that is constant and not going away, while maybe the numbers of unsealed eviction filings may show a decline. Really, the behavior has not changed. This is just another here, and I'm looking at time, so I'm going to kind of speed up here towards the end. And this one, I'm just going to kind of go a little more quicker. But really here, this is one example, one of those lawsuits. It was a 20-unit property that was acquired in March of 2016. And within a few months, there was already a building-wide lawsuit filed. And here, just kind of the timeline of how rapidly this happens, where March 16, they get the notice, property was sold. April 8th, parking spaces we're going to announce that they're going to be rearranged, so they need to be discontinued using them within 10 days. April 25th, construction at the property started. Renovations were happening late at night to interfere with the quiet enjoyment of the premises. April 30th, tenants' screen doors were removed. May 1st, when it came time to pay rent, when the tenants tried to visit the manager to pay, it was on a weekend, and she was quoted saying, "I don't work on weekends," did not accept the rent. May 6th, security parking gates for parking spaces were removed. And then again, May 10th, like we have new space arranged, non-compliance will result in being towed. So it's just the rapid behavior, predatory behavior that occurs right when properties are acquired. Then you have here just more examples of what was shown earlier. Oh, again, these tenants of these receiving these 3-day notice, alleging unauthorized occupants. Same thing, it was found here throughout the building. So out of the 20 tenants in the building, 10 were part of this lawsuit. The last thing I wanted to kind of go over here is really the kind of informal evictions, which I know it has a challenge for researchers to really look at that because it's not documented. But really, what kind of provides some tools to look at that is through the city's housing department's rent registry program, which they started in 2017, where landlords have to report on an annual basis the tenants' tenancies, their move-in date, and then kind of their rent portion. And so unfortunately, they did not share the rent amounts, but really what I was looking at is tenancy turnover. So the dates here, this is the move-in date. So if the move-in date is the same, that means it's, as the following column, that means it's the same tenancy. And in here I highlighted in red, which are the tenancies that had been replaced, or in this case, vacant. So this property was acquired in January 2018. When they acquired it, these were all the tenancies that were living there. Once by the following year, when Abraham Stein reported the tenancies, we saw here the number of tenants that were displaced, leaving, that's what's in yellow, leaving about only 57% of the tenants of the original households that are living there. Here's another example of a property that was acquired in November 2016, just showing here again what's yellow, the original households, and red, you just see the yellow declining, where it leads by, again, by the end of 2019, that again, only 8 remain out of the original 17 that were acquired during this period. So applying this analysis to 28 of the properties, here's a breakdown of showing just the percentages of tenants that still remain original households that are still living there for properties, again, going back to 2010. And the what's red identifies that our original tenancies 50% or lower that still remain. And just taking the average of all these properties, it comes out to 44%. So again, this eviction machine is being operated or utilized at every year, while the eviction seal or the formal evictions may not show that really through these rent registries is showing that tenants are constantly being displaced. And it's not even also just original tenancies. I see here are found that even some tenancies, say in this case, a tenancy that moved in here in 2016, it was replaced with a new tenancy in 2018. Same thing here, moved in 2015, replaced in 2018. So whether the tenants were, in this case, could be seen whether they moved out on their own because they were disappointed by the services and the treatment, or whether they actually were forced out, the same mission has been accomplished of being able to get tenants out and to reset the rents. And so that's what we see here, even every year, the number of eviction or just turnover that is happening on a year basis. And then again, on this column, that the units also will be turning over even after tenants have been accepted by Abraham Stein. Doesn't mean that they actually will remain there. And so just the last thing here is really looking at this relationship between formal and informal evictions to make an estimation of how many of, based on the number of evictions, formal evictions, how many are actually informal. And so looking at these same properties, what I did was kind of like look at the turnover, tenancy turnover, deducted the number of unsealed eviction cases to kind of look at the informal cases that also kind of account for some of these sealed. And the ratios, looking at these ratios, it comes out what I have calculated here with these ratios of looking at unsealed versus informal evictions, that for every one unsealed eviction, there was 6 informal evictions that took place. And so applying this ratio to the total eviction filings that I had stated earlier of over 1,500, I estimate that this eviction machine potentially had already resulted in up to 9,000 informal evictions between 1996 and 2019. So the evidence was clear here that this is a comprehensive examination of really what an eviction machine looks like, target at Black and brown bodies. And just to conclude, what this study is really showing is, again, this transformation of landlords from fully liable owners into these partially liable anonymous LLCs. It has enabled predatory landlords to thrive and further exacerbate this commodification of housing, deepening the conflict between housing as a home and housing as real estate. And really to understand that predatory landlords, are a unique class. They cannot be regulated through the standard policies that apply to all landlords. The existing procedures of housing enforcement, are not equipped to deter or stop predatory landlords. We see when new kind of policy being passed, usually politicians or public officials will say, we're putting all landlords on notice. But in reality is that there's a specific class of predatory landlords that disregard and find ways to be able to find the loopholes or use the existing regulations to still evict and displace tenants. So clearly, with the majority of you all here who are doing the hard work, we know that the only way to make change is actually through organizing for change. And I thank you all for listening, and thank you all already who are doing the work on the ground. And I know we will be hearing some more real life examples of the work that's being done today. But I will thank you all for your time in this presentation, to providing this presentation. And I guess I will also take, some questions if there's any. Here's my email. You can find me here. I guess just a new Twitter account that I had just created that, because I had mentioned that doing some of the work with the Institute of Inequality and Democracy at UCLA, I am been working on some new research of kind of showing some of this behavior operating in different ways. So I'll probably be sharing that there when it comes out. But that is all for me. Thank you.